Today we're going to be talking about digital accessibility, and we are thrilled to have David Berman giving this presentation. David and his team are the absolute experts on this topic. David holds every certification for e-accessibility from the International Association of Accessibility Professionals. He is one of a handful of people around the globe who deeply understands the issue of accessibility. As we were working with David and one of our other clients, one of the things that came to light is the upcoming deadline under the Americans with Disabilities Title II Act, and David will walk through this. He's got some great history on it. I have really enjoyed getting to know David over the past 2 months, and I have already learned so much about e-accessibility. As someone who works on the ProTech website, I've already been making some changes to make our website more accessible. So I think you'll find this really interesting. David has a lot of great information, and David will touch on this at the end. Please connect with us. We already have classes on the calendar around these digital accessibility topics. David will go over those. And please make sure to connect with ProTech on LinkedIn. We're in the process of updating some of our email stuff, but one of the best ways to connect with us, and I often post discounts on our LinkedIn page, which is another reason, and we've got a LinkedIn newsletter that we've just started. So I'll post the link in the chat, but please take a moment to follow ProTech on LinkedIn after the webinar. So let me hand this over to David. Thank you very much, everyone, for joining us. And David will go over some of the ground rules as part of his introduction.
Thank you so much, Lindsay. I'm so excited that we have such a huge crowd today to go deep on this. It's an honor again to be in yet another ProTech event, and thanks for all your work, Lindsay, setting that up. Indeed, today we're going to examine what we need to do to meet the ADA Title II accessibility deadlines. And I have to say that I've worked with government and private sector organizations in almost every of the 50 states and on 5 continents on helping them make their websites, their documents, and their apps accessible. And I can tell you, every team we first meet is understandably a bit intimidated by what's requested. They're also understandably worried that it's going to be really expensive and time-consuming, and indeed, that could happen if you don't know the best way to approach it. Now, from my background, I started off as a graphic designer, and we've been doing events for ProTech back to 2008. And back then, we were doing design work as well as accessibility. Now, accessibility has come at the core of what we do. And when we were first involved with accessibility, I, as a communications pro, was terrified. I was afraid it was going to reduce the quality of our communications, make us have to make compromises. And I promise you that I can show you. Today we'll touch on it, and in the courses that we deliver for ProTech, we can go into the nitty-gritty details of how we can transform the process so we can make sites and documents and mobile apps better for everyone while driving down costs that will actually save money by making stuff accessible without trade-offs for the typical audience member. Before we get into this, as Lindsay said, we're going to start off with some ground rules. And distance learning, like we're doing right now, is simply a bucket of temporary disabilities. So joining us remotely is somewhat of that experience. By creating an experience which delights everyone, we can also create a better event for everyone. So whether you're on Windows or Mac on the desktop, or whether you're on a tablet or your phone, your team's interface should include being able to presenting me waving my hands here on camera, as well as my shared slides, and it should be broadcasting my voice. So if anything's not working as you desire, please ask for help by using the chat. You can target Lindsay for that. And just like in a real room, if you just gotta share something, please raise your hand. In the interface, that's the raise your hand button. You can lower your hand with the same tool, and Control-Shift-K if you're on Windows, by the way. Now for the audio for the event, if you do happen to be invited to speak, please mute yourself before and after. And regarding the video, in case you're relying on seeing the presenter, know that in Teams you can see the full landscape view of the presenter at any time by choosing the Fit to Frame command on the tile that has my little picture on it or Lindsay's little picture. Now, finally, today we have captioning enabled, Lindsay. And so
yes, I believe everyone can turn on the captioning through the Teams portal.
Okay, so if you need captions, you've got to turn on the captions command, which is show live captions. It's from the go to more, and then go to language and speech menu, and then choose show live captions. So I know you're eager to learn all about ADA Title II regs, but in order to understand the regs, we've got to understand the Act, the Americans with Disabilities Act, which came about over 20 years ago. And it starts, arguably, with a protest that was taking place at Gallaudet University in Washington, D.C. in 1988. There's actually a really great Netflix film available right now called Deaf President Now, and it's very well done, and it's delightful. So I urge you to check it out on Netflix, not our sponsor. However, what happened was that the students of the only deaf university on earth in 1988 protested, saying they wanted the president of the university for the first time to actually be a deaf person, not a hearing person. And indeed, it ended up them making a march on the Capitol, because it's only about a 30-minute walk from Gallaudet University on a good day to the Capitol. And meanwhile, in this time, also people with mobility challenges were having sit-ins and protests pushing for the idea of this act coming forward, because the act was drafted based on the triggering by Gallaudet University. But then it was taking over a year for the act to go from being a bill to a law. And so there's this remarkable demonstration where people with substantial mobility challenges actually drag themselves up the very stairs of the Capitol, in the Capitol, and to make that demonstration. And it's argued that that's what ultimately caused President George Bush Sr. to sign into law the Americans with Disabilities Act, which arguably is one of the greatest pieces of human rights legislation in the history of civilization. And it's been a beacon to nations. Now, beyond that, something called the Web Content Accessibility Guidelines were actually developed starting at a university in Wisconsin, University of Wisconsin, in 1999. Now, note that that's 9 years after the Act. And the reason that really matters is that the Act predated the ubiquity of the web. It predated the ubiquity of the internet. And so the Act said nothing about digital accessibility. Meanwhile, other presidents signed into law other accessibility laws. And so in 2010, President Obama with the Plain Language Act, and 2018, President Bush signed the Marrakesh Treaty, which allowed textbooks to be converted into accessible formats for the first time without going against the Copyright Acts. And this was an international treaty, and when America signed on to it, it now had enough signatures to be a global standard. In fact, it was arguably the only unanimous bipartisan bill passed in President Trump's first session. So this challenge is that this thing called WCAG, WCAG, it's going to be referenced in Title II, a certain version of it, WCAG 2.1. And in order to understand the regs, in order to understand the Title II final rule, we have to understand what WCAG is, WCAG. You can call it WCAG. You can say WCAG, because that's what the screen readers announce. If you say WCAG, you're going to sound like you don't know what you're talking about. So WCAG or WCAG. And WCAG is a voluntary standard developed by the W3C. This is the international organization headquartered in the United States, which sets almost all of the standards we use to run the web and the internet. PHP, HTML, all that is a web standard. So there's all sorts of standards, and WCAG is just one of many standards developed by the W3C. And it includes a series of success criteria that we must pass in order to be able to declare that something conforms to WCAG. So WCAG 2.0, which was the first version that was in the law in the United States, because Section 508, the federal law governing the accessibility of, let's say, the White House or federal departments, calls for WCAG version 2.0. We're going to be talking about a version called 2.1. But whether it's 2.0 or 2.1, it is the standard that is seen in regulations all around the world. And which is very convenient because it means the tools in the ecosystem that can help us conform to ADA Title II are tools that are being used all around the globe. And so the original Section 508 started with WCAG 1, then it was revised to 2.0, and that's where it is today. There's laws in Canada, laws in India, laws in the EU, all around the world, all regulations that call for some level of digital accessibility, reference some level of WCAG. Now, WCAG 2.1 is the version that's now the most popular on Earth. And so it's great that when the DOJ decided to publish the Title II final rule, the regulation, that they chose WCAG 2.1 AA. And if in our courses, we go very deep on every aspect of this. But just today, we're going to be identifying that this is the measuring stick that we'll be using to make sure that our state and municipal governments are complying with the new regulations. So just whether you're looking at WCAG 2.0 or 2.1, WCAG comes in levels. Some of the rules in WCAG are level A, some are AA, and some are AAA. So in order for us to declare that something is AA, what conforms to WCAG 2.1 AA, we have to fulfill all the level A rules. If you fulfill them, you can say your product, your document, your site is WCAG 2.1 level A compatible, compliant, conformant. The ADA is calling on us to actually conform at level AA. So for that, we have to meet every one of these rules. We call them success criteria in WCAG. Every one of the level A success criteria, as well as the AA success criteria, we have to meet all of them in order to be able to declare that the entire mobile app or document or website conforms to WCAG 2.1 AA. Now there's 30 of these success criteria at level A, and there's 20 more at level AA. So that means in total there are 50 success criteria that we need to meet, match, take care of if we're going to conform to 2.1 AA. Now there's also success criteria called AAA. And if you're a real keener, you may be thinking, oh, we're going to do those ones as well. But the challenge is this. I promise that we can create a product that fulfills every level A and AA success criterion without trade-offs. That is, by in ways that are either not even that the typical audience member won't even notice, or improves the experience for all audience members. But when we get into these AAA success criteria, we do have trade-offs. And so it's very rare for anyone to create a product that conforms to all the AAA success criteria. It's more typical that you'd get into them if you had a product specifically for people, for an audience that is mostly people with a specific disability, in which case you would intentionally have that trade-off. And so you get into those AAA success criteria. However, I urge you, don't try to embrace the AAA success criteria all at once as well. We're focusing today and in our courses on WCAG 2.1 AA.
Hey, David, we have a question looking for some clarification here. Renee asked, is the reference for some people, is this the general public or specific groups or individuals?
That's a great question, Renee. And so Renee, thanks for bringing this up. So when on my slide, I'm saying that without level A, some people will find it impossible to get things done. And without level AA, some people will find it difficult to get things done. And so Renee's asking some people, which people are we talking about? So I'm saying, let's say in the population, in the general population, I'm saying amongst that population, some people will find it impossible. And in the United States today, the latest statistics say that 18% of Americans or residents of the United States live with some substantial disability. So that's some people, could be 18% of the audience will find it impossible to do top tasks. And then with AA, if you had a level A website, but you didn't do all the AA, then 18% of people would find some difficulty in getting things done. And I see also, Carolyn, you're jumping ahead to, yeah, but how much time we got? And Carolyn, I promise, once we understand WCAG, I'm going to get into what the deadlines are depending on the nature of your entity. So the difference, so before I move on from identifying WCAG, a lot of people often ask me, hey, we've worked really hard to make our products already WCAG 2 AA. Because, for example, let's say we were getting federal funding under Section 508, and they wouldn't allow us to have that money unless we promised the product was WCAG 2.0 AA, because that's what Section 508 calls for. What about how much? Now we got to do it all again in WCAG 2.1? And the good news is that 2.0 is a subset of 2.1. That is, when 2.1 was published, we kept all of the 38 success criteria, a level A and AA, you'd require to make something WCAG 2.0 AA conformant. And then just 12 extra success criteria were added. So the great news is, if you've worked to create anything and certified as WCAG 2.0 AA, then you're done with 38 of the success criteria. And now you just have to look at the 12 new ones and see if you've got some more work to do there. And it's going to be the same with WCAG 2.2. 2.1 will be a subset of it. So this WCAG 2.1 A and AA success criteria, I'm showing a screen where I list all 50 of them. And on the screen, I'm also showing that there's only the 12 that were added for 2.1 to get us to AA. So you only have the 12 to worry about if you've already worked hard to make something WCAG 2.0 AA conformant. And this WCAG 2.1 standard is now embraced all around the world. And the majority of countries that have regs that call for WCAG conformance call for WCAG 2.1, not 2.0. So it's becoming easier and easier to do that. Now, in addition, before I get to Carolina Thatcher's question about when do you need to meet the deadline by, we're going to be talking about the deadlines for ADA Title II, but that doesn't mean that there aren't already laws in place that already call for accessible websites. So sometimes, for example, you have state laws in California and Colorado and Tennessee, et cetera, that depending on who you already need to have your website accessible to a certain level. And even though I'm going to show you deadlines for ADA Title II that haven't come yet, it's very possible that depending on your jurisdiction and your nature, that you already have to conform. But we're only going to talk about deadlines. And Ellen, what I'll do is we'll make the deck available after the event. Perhaps Lindsay, how about when we announce that the recording's ready, we could also provide a link to the deck as well. Does that work for you, Lindsay?
Absolutely, and we could also put the deck on our website.
Mm-hmm. Okay, and Renee, I realize I didn't go as deep as you'd like. However, if you send me an email afterwards, I'll be pleased to give you a deeper answer to the question about about how that 18% was measured and how it impacts, because it's a bit of an apples and oranges situation. My email address, it's on the last slide, but also it's berman@davidberman.com. If you have any questions about anything I bring up today, or of course, you can email ProTech and ask them to to contact us, my team, my expert team. But I don't have the answer. We have a remarkable group of unicorns who will. So I've just included examples of states that are amongst those who are leaders in this. So, for example, Colorado already has demanded of state government and municipalities and things that are funded by either already need to conform to WCAG 2.1 AA, and similar it is to California and other states. So let's get back to this Americans with Disabilities Act. The ADA has 4 titles. That is, it has 4 big parts. Title 1 speaks about the obligations of employers across the country. Any employer who's not the federal government is indicated as needing to create an accessible environment for their employees if they have 15 or more employees. So it's already the case that if you're a state government or a municipal government, or let's say a university that's funded, you already have an obligation under the ADA to create an accessible environment for your employees. But Title I doesn't designate how we define digital accessibility for people doing their jobs. Now, Title II is all about public entities, and that's the state and municipal government. And for years, although the Department of Justice, the DOJ, would touch upon the idea of, yeah, you really ought to make your digital, internet-y, webby stuff too accessible over the years, they didn't get around to actually saying, here's the measuring stick. Let's measure using the stick that we all invent, that was invented locally and is used all around the world in regulations, which is WCAG. Now, Title III is business and nonprofits. And so that's the business community that aren't public entities, also are obligated under ADA. And again, they don't yet have any regulations that declare how we're going to measure digital accessibility. And then finally, Title IV is special rules for telecom companies. So Title II, first you have to say, okay, well, what applies to my organization? So for example, if I was a private university, entirely private, I'd be under Title III, not Title II. But if I'm a state university, or I'm a community college who's completely funded by the state or by a municipality, then I'm under Title II. And maybe there are even mixtures of that. There's private universities which may receive state funding for some aspect of what they do, then those activities would fall under Title II. And as well, so the remarkable thing that occurred in 2004 was that, but from 1991 to 2024, the DOJ kept hinting at the idea. They'd say, yeah, we think we're going to come out with basically a proposed rule. And in US law, a rule is a regulation. So regulations are broken down to proposed rules. That is a regulation that's been drafted. It's in public consultation. And then a final rule is what they call a regulation that's actually been published. It's been released. It's been enacted. And so for over a decade, there was talk about the idea, but it wasn't until 2024 that the DOJ finally published a final rule, in other words, a regulation for Title II. And they're still thinking about doing the same thing for Title III. So in June 2024, the DOJ published this final rule, this regulation about ADA Title II. And the takeaway was that if you're a Title II organization, you need to conform to WCAG 2.1 AA for all your websites, apps, and documents. And the deadlines to come back to Carolina's question, depends who you are. So the majority of Title II entities have a deadline of April 24th, 2026, which is very soon. However, if the entity has a population of less than 50,000 or is funded by government in a district which has a population of less than 50,000, then you get an additional year. So either if you're Title II, you either have a deadline this April, or if you're in a small population area, then you have a deadline that's a year from April 2027. And of course, any state government is more than 50,000 people in its jurisdiction. And so therefore, we're talking about the number of residents. We're not talking about how many staff there are. So all state governments have the deadline in 2026. And so the next question is, what does the regulation, the final rule, cover? It's odd they call them final rules, because it kind of sounds like they're saying, we promise there's never going to be another regulation for ADA Title II. But that's not what they're trying to say. They're just trying to say a regulation has been published. There could someday be another final rule under Title II. There are already regulations about Title II before this that weren't about digital accessibility. So what's covered is this: websites, which includes web-based applications, so anything browser-based, mobile apps, conventional electronic documents, and the term conventional electronic documents, which in my slide I have in quotation marks, because we have to we have to say, well, which documents? So they've actually defined it. They said these are all documents that are available from a website or a web-based app or a mobile app that are either PDF files or word processor file formats, which is being interpreted as Word files and similar, presentational file formats like PowerPoint files, and spreadsheet file formats. So essentially, it's the big three from Microsoft Office or equivalents from other suppliers and PDF files. So we're talking about PDFs, Word, PowerPoint, spreadsheets. Those are the conventional electronic documents. Now, in teaching situations, they go a little deeper. And so the fourth item on my 5-point list is course content. So for course content, if you happen to be, let's say, a state university, then they also include in the scope, no matter what the format is, if you decide to put that in the course pack and the learning material for a course, then they also need to be accessible. So if the electronic document, for example, was an EPUB file, then those EPUB files, because they're part of course content, also need to be accessible. And finally, the last item on this list of 5 things is social media posts. And Lindsay's reminding me that there's a page on the ProTech website where we put a summary of this information as well. It's in the chat. Now, there are things that there are exceptions to what's in scope. Archived web content, which means stuff that is old and you promise you're never, ever, ever going to change. Things that were conventional electronic documents that were posted before the deadline. And there's an exemption from that exception if those documents are in current use and you can't participate in a service or a program or activity by doing so. So let's say you're a municipality and there's an online form that if you want to sign up for the municipal swimming thing for your kids, even though that form was created before the deadline, it hasn't changed and may never change. It has to be accessible because it's linked to a current program. There's also exemptions for content posted by third parties, password protected documents that originate from individuals, and any social media posts that were posted before the deadline are exempt. But as are only things that are posted, let's say after April the 8th of your deadline. And in this deck, I'm not going to go into the details unless people have questions of them, but in the deck that you'll get afterwards, we've gone to the detail of unpacking very specifically, what does archive web content mean? What does the minimal impact on access exemption mean? There's also an exemption for what's called fundamental alteration or undue burden. So there are various situations where you can request an exemption or can be exempted based on the rules and the regulation. But in general, most of the content you have is not going to fall into one of these categories. And so you have to figure out how to attack it. There's also existing rules, existing regs about Title II that have to do with on-demand requests. And they haven't changed. So for example, let's say I'm a resident of Oshkosh, and we have so many people from Ohio with us today. I'm going to say I'm a resident of Columbus, and I go to a city council meeting, and I want to get the minutes, but I want them, but they're not available in my preferred accessible format, like let's say a large print edition or a Braille edition. There are very specific rules about what you must do versus what you should do in terms of on-demand requests. And so ADA Title II is saying our existing rules for what you need to do regarding on-demand requests stands. And so we've added some stuff to this deck that helps explain how this plays out with in Title II final rule. There's also a really important rule, aspect of the rule, which has to do with contracts with outside bodies. So for example, let's say state government of Hawaii is licensing a third-party application to help people pay their traffic tickets, let's say. Well, just because you outsource that and put it on your website doesn't mean you're not just as responsible to make sure residents can have a WCAG 2.1 AA conforming experience. And so again, we get it when in our courses from ProTech where we unpack this deeply, we go into deep details with examples of each of these situations. So for example, we'll coach you through the idea of making sure that your contracts with those third-party vendors are airtight, so you can be confident that you're not going to be left holding the bag, and that it'll be they're contractually obligated to make sure that by the deadline, those products are ready to conform to WCAG 2.1 AA. There's also an interesting twist in ADA Title II in the regs regarding WCAG's definition of conforming alternative versions. In general, WCAG allows for us to say, well, this PDF isn't accessible, but the same content is already available online in an HTML page, and so you can declare that. However, Title II is especially tight on this matter. So if you have a situation like that, it would be really helpful to learn about where that line is drawn and the techniques one can use to make sure you're conforming to the reg with the minimum amount of effort, and of course, serving residents to the best of your abilities at the same time. Now, people also often ask, what about Title III? Either because maybe you just realized 20 minutes ago, you're not obligated by Title II, but you're definitely Title III, or sometimes there'll be operations that have a foot in each world. And the intention was that the PACE would have seen that the DOJ would have been publishing very similar rule set for Title III organizations, perhaps paced around 2 years. However, because of the current administration's focus on reducing the amount of regulation in the country, it's currently a bit of an unknown as to what the pacing is currently for similar regulations to apply to Title III organizations. Now, I'm also throwing this in about HHS because a minority of you may also receive funding from the Department of Health and Human Services, the federal department, HHS, because they've also established their own WCAG 2.1 AA deadline, and it's only a month after the first deadline I mentioned, or it's less than a month. It's in May 2026 for organizations with at least 15 employees, and a year later for fewer. And so if you happen to have any programs that are relying on HHS funding, then let's say even if you're a municipality with less than 50,000 residents, if you have 15 plus employees and you're getting HHS funding, then at least for the operations of that program, you have an obligation to be WCAG 2.1 AA conforming by May 11th of 2026. So we have a whole course about how to strategize the attack. So whether you attend a public course, ProTech on accessibility, or whether you hire us to have a private course online or on site, this is the overall framework we're going to do our best to lead you through as you prepare for a mature approach to WCAG 2.1 AA conformance, and therefore complying with the regs. And so these 5 top tips, I'm just going to walk through them. So the first is that, of course, first of all, we have to figure out which regulations actually apply. And then confirm that our internal accessibility policy actually mirrors that. Because if we don't go to the trouble of making sure that our culture is aligned so that we are creating things according to our own policies that are accessible by default, then we find ourselves constantly chasing this challenge. That is, we create something and we say at the last minute, wait a minute, is this accessible? We say, oh no, it's right, it's going to be accessible. Well, there isn't a more expensive, more painful, or less effective way to make things accessible than having it be the last step. And rather, the philosophy will teach you is how we actually build accessibility in from step 1. That doesn't just make it possible to drive down costs, to be done faster, but it does something also that's profound. If 18% of Americans are living with a substantial disability, and we're creating products and services, so imagine 18% of your workforce is living with a disability. Well, it would be a real shame if they can't be a part of the process of creating great stuff. But if we make things accessible by default from step 0, then everyone could be involved in authoring content, in designing. In fact, the extra biodiversity of input we get from people with varied experience actually results in better products for everyone. So that's number 1. Bake it into our accessibility policy. The next step, number 2, is to take inventory of everything we've already got, because, and certainly with a deadline that's so soon, you probably have already begun some of this work. So we can help you figure out how to make sure you found all of the apps and the websites and the documents and maybe EPUB files, et cetera, course materials, social media, that's going to have to be in scope. Now, the third big tip we give is something we call reducing the rot. That is, reducing the amount of redundant, outdated, or trivial material, because it's a great opportunity to say, hey, do we really need all 2,000 of these pages on our website? If 500 of them are out of date and are kind of in the way, they're too much stack, not enough needle, this is a great time to thin things out before we bother to go through and make sure we make whatever is left standing accessible. And then 4 and 5 are about training, because ultimately we need everyone involved in developing sites, whether that's authoring, coding, managing, validating, testing. Everyone's got to learn how to create accessible products. And so for everything that's developed in our organization, we want to make sure that our strategic plan includes training, as well as tools and auditing approaches to make sure that we can demonstrate that our products are accessible. And then for everything that's outsourced, like the example of the parking ticket system for Hawaii I mentioned before, which may not exist, I just made it up. We need to train our procurement teams to make sure that they know how to buy stuff with eyes wide open, to make sure the contracts, the RFPs, the request for proposals, the standing offers are all set up to guarantee that when someone gives you a product, they don't just say, oh yeah, our people in our, yeah, it's accessible. No, there's an industry standard way of demonstrating that something's accessible. And it's called an accessibility conformance report. Or often you'll hear of it called a VPAT, VPAT. They're called, VPAT is actually the name of the template that we follow to create something called an accessibility conformance report, an ACR. However, the VPAT was invented in America. It was invented for Section 508. And 10 years ago, the resulting report was also known as a VPAT, a VPAT. So if you hear someone saying, oh yeah, I need a VPAT, or we have a VPAT for that, they usually mean we have a document that followed the VPAT template. Or they may say we have an ACR. The terms are effectively interchangeable. And they're international standards now. So for example, if you decide to license software from someone in the Netherlands, they'll offer you an ACR declaring that the product meets or exceeds WCAG 2.1 AA. There's different versions of VPAT for 2.0, for 2.1, 2.2, but the point is you need this formal declaration from the supplier that declares that, yes, it's not just us saying it, a certified professional has declared that this product meets or exceeds every success criterion in WCAG 2.1 AA, and therefore that's how we demonstrate that it helps us comply with WCAG 2.1 AA in support of Title II, or any state law or any other regulation that applies to your organization that requires WCAG conformance. The document looks like this, and there's different versions. You could certainly have your own people learn how to do this yourselves, or we could teach them how to do it, or sometimes people will contract out for more complex things to organizations like ours who are constantly working on VPATs for a variety of products every day. I've included in this deck a checklist of how to make sure the VPAT they give you is a great one. So I've included that in here. However, that's the overview I wanted to give you. We've also included, we have at the wcag2.com site, we have more resources about all aspects of e-accessibility. It's a curated library that if you have stuff that you'd like to share with the world, we'll add it to that. And we've also, as Lindsay alluded to earlier, we've set up a page at ProTech's website, protechtraining.com/digital-accessibility, where we have FAQs, we have the list of the upcoming dates for some of our accessibility courses that you can join publicly. I've included that on the slide. We have a one-day course on February 23rd, a two-day course on February 26th to 27th, and a three-day course March 9th, 10th, and 11th. And of course, there'll be future dates of all of those as well. And then the majority of the events we do are private bookings where we tailor the events to fit. Lindsay, I feel like maybe you should be speaking to that rather than myself. So I'm just going to open up the floor for questions, or Lindsay, maybe you could open up the floor for questions and on we go.
Sure. If folks have questions, please put them in the chat and we'll go through them. I also have a question for the group in terms of how can we help you with this information? Are there newsletters that would be good for us to connect with? One of the things I was thinking about is, would it be helpful to create a LinkedIn group for technology for state and local governments? I did some looking and didn't find one, but maybe there's one that existed. But as we have more classes and resources like this, what's the best way to distribute this information to you? Because we're always looking for ways to put our information in front of you. And we also have some helpful AI classes coming up, and we've seen a lot of interest from our state customers around AI. So if anyone has suggestions on how you would like to hear from both ProTech and David Berman, please put those thoughts in the chat, or you're welcome to reach out to me individually. So David, we have a question from Liz Anderson. with a couple of thumbs up. Are there also sessions that concentrate on PDFs, or does this fall into the PT 21960 course?
Well, that's a great question. I'm glad Liz brought that up. So I'll address that right now. So the 2-day course I mentioned earlier, the PT 21960, is about accessible Microsoft Office documents, and it touches on making them accessible and then exporting them to accessible PDF. But we also have, aside from these 3 public courses, you'll see that on that webpage, we have over a dozen different accessibility topics that we can focus on. Everything from accessible multimedia to accessible meetings like this one. And so when we talk about PDF, we have to break it down. So we can do, let's say, a private course just for people who already know how to make accessible documents in, let's say, Word or PowerPoint, but we need to learn how to make the PDF that's exported, make that PDF into an accessible PDF. We also have a course where we focus on nothing but someone gives you a PDF. You don't even have the source document it came from. How do you make that PDF into an accessible PDF? So we break down the accessible PDF challenge in a number of ways. The greatest PDF challenge is dealing with fillable forms that are PDF files, because that's the toughest kind of PDF to make accessible, but it's also the biggest opportunity to drive down costs if everyone can fill in forms successfully. So Liz, all to say, we touch on this in the accessible Microsoft Office course, but we also have courses available that focus on nothing but PDFs, different varieties of PDFs. Does that answer your question?
We have some more questions here, David, and we will go through them. I also just want to take a moment to reiterate something David talked about here. While we do have these courses scheduled for February and March, ProTech is able to work with you and your organization, whether you're a business or government, and put together a training that works with the dates for your organization. We really do both of. You can attend one of our scheduled trainings, or our education consultants can work with you and put together a specific training around this, or a package of trainings that work for your government organization, or if we work with private clients as well. But this webinar, we're really focused on this federal deadline. So I really targeted this webinar at US, state, and local governments. But if you have not worked with us in the past, please don't feel limited by the dates that are on our website. Drop an email. info@protechtraining.com goes to several of the partners and myself. So that's always a good way to get in touch with us if you don't have a ProTech rep yet. And we'll be happy to help you, talk through with you, and put together a training that works for you. And we have done plenty of work with governments across the country, and we're well set up to work from a procurement side. Okay, back to the questions. Kevin says, I've heard mixed things on how all of this is being enforced. Is it just enforced by lawsuits by users, or is there a government/agency enforcement for our website stock, etc.? Are the audits done via the DOJ or another agency?
Kevin, it's an excellent question you bring up. And due to the anomalies in regulatory enforcement going on in America today, there's a lot of discussion in the legal community as to how enforcement will take place, because we haven't passed the deadline yet. Some speak to how, in general, some regulations are not being enforced as strongly as they used to be, while others identify examples, for example, in the higher ed community, where organizations are doubling down to make sure they are following regulations in case they are concerned that someone's going to specifically want to find a way to point out how they're not following federal regulations. So, but historically, in the history of the last 20 years, enforcement comes from 2 places. And the majority of it comes from the accessibility community itself. the United States has a very proud history of activism in the accessibility space. And so very often, let's say a lawsuit will originate from an individual who's arguing that their human rights have been violated or held back. And so they attempt to get what they feel they deserve. And when they don't, they lawyer up. and so that reactive approach, and sometimes so those lawsuits have found themselves in the last few years, in two cases, all the way to the Supreme Court, have perhaps the biggest impact. It's not, as opposed to wondering, is the DOJ, for example, have a practice of going out and looking for people who are violating this type of regulation? Are they doing spot testing? I can tell you that in the past, the majority of issues have arisen from individuals with individual claims that become either demonstrated to be spurious or are fundamental or anything in between. Kevin, is that a substantive enough answer to your question? All right, then. Thank you.
The next question is from Tamara. I hope I pronounced your name correctly. We've been told that we should move PDF documents into content on the site instead of using PDFs. Is this a recommendation?
So Tamara, that's a really good question. And in fact, there was, as I identified in my presentation in this deck, we go very deep on a number of the vagaries and the details about the exceptions and the exclusions. And you've really touched. And so if anyone has any questions about those, we can go deep on any of them. And this is one of them. So one of the challenges of ADA Title II is that this reg says something that I've never seen in any regulation on earth about digital accessibility. And I'm pretty sure we're familiar with them all. And what it is I spoke about this very briefly, that they talk about declaring a variance from WCAG's, what we call a conforming alternative. So Tamara is asking, we've been told that we should move PDF documents into content on the site instead of using PDFs. It's very common for people to say, I've got this PDF full of content. I can either make it accessible, or maybe it takes less effort to put the same content in another format, such as HTML or a Word document, and also put it on the website, and then say, hey, everyone, here's the information. And by the way, if you'd like this in PDF format, it's over here. By the way, we warn you that PDF file is not accessible, but there's a conforming alternative. That is to say, it is available in the HTML, for example. So if you're looking for an accessible approach to the content within this PDF that's only has limited accessibility, please go look at this HTML here. And in general, the thinking was better that we have it in both accessible HTML and inaccessible PDF than not have a PDF at all. But if you read the law, the reg, it does actually say, it seems to say that actually, if you put the PDF up, even if there's a conforming alternative, that PDF's not okay on your website after the deadline. And so there's been discussion in the legal community about the rationale behind this. And indeed, in the regs, if you're interested in the detail of this, because you can read all the feedback that the DOJ gave on all the public input there was on the regulation, and it's impressive. There's like 50, 60 pages of this stuff. They really thought it through carefully, and they lay out their argument of why they feel strongly that it's important that each presentation be accessible. And it's certainly defendable, but it's uncommon. So all that to say, Tamara, that even if you weren't trying to create a Title II complying presentation, some people would argue that we could move our PDF content from the PDF file into another format, such as HTML, and then no longer offer the PDF. And that's a fine approach. But in most jurisdictions, you would have still left the PDF behind for those people who have an interest in that original presentation. Maybe they want to print it and they want it to look exactly the way it was published or something like that. But the ADA Title II seems pretty clear that you must move the content or make the PDF accessible. And that's why I can especially see how some people have been encouraging you to actually move the content from PDF to HTML because it may be less trouble than publishing in PDF. As well, many users, especially people with living with specific disabilities, definitely will prefer that HTML over the PDF. So that's a big issue, and it's a lot of work, of course, to move. You may have thousands of PDF files, and so you may be struggling with that challenge. And again, we can certainly advise you on how to do that. Like some of our clients, some of our engagements have involved clients with tens of thousands of PDF files, and we work with them to develop a strategy where you could actually break it down. We end up figuring out, okay, this group we're going to make accessible. This group, we're going to just take off the site forever under the remove the rot construct that I mentioned before. And some we're going to permanently move to HTML. I think if you have a lot of PDF, the right answer is going to be a divide and conquer approach that involves some really good strategic thinking. And it's really possible that a small amount of planning with those who have done this before could save you piles of money and piles of person years of effort only to discover you've gone down the wrong path. Tamara, did I answer your question and have I gone deep enough?
She said yes. Thank you.
You're very welcome. Great. Okay.
Jumping back up a little bit here, what are the punishments if not meeting the federal regulations? And also, do the agencies need to update the DOJ or someone else if they do meet the regulations?
Yeah, so Renee, the potential monetary punishments are mentioned in the regs, and so yes, there are punishments. And if you want to go deeper as to what the punishments look like, then you can look at the regs. But also, it's also possible that the financial cost could be much greater than any penalty in the regs, because if there's a lawsuit, it's possible. Like there's been lawsuits. There's American banks who've paid out $11 million lawsuits based on one complaint of someone not getting what they deserved. So I think that when you're analyzing the financial punishments, you should think about the potential for litigation. And that also comes down to how big a target you are, how large you are, and who you are, and et cetera. But there's also other punishments in terms of public engagement and in reputation. It's in some communities, it'd be especially difficult if you had a reputation where you're not putting if you're not perceived to be putting a substantial amount of effort into making sure that no one's left behind when it comes to providing public service.
Okay.
Renee also mentions, I'm sorry if I may, Lindsay.
No, go
Renee
ahead.
also goes on to ask, Lindsay, I have more time if we want to stick around a little longer.
I'm available to stay on as well. So David and I we'll let anyone who needs to go. David and I will stay and answer as questions until we're done, or at least for another 10 or 15 minutes at the most. But for everyone who needs to go, thank you for attending. Please connect with us on LinkedIn. Please visit our website, and we look forward to working with you. Don't hesitate to reach out to either David or ProTech, info@ProTech Training. We'll be happy to help you, and we'll get back to answering some questions here. All
Oh,
right.
and
So
Lindsay, I have to interrupt because if folk are
sure.
leaving, I just want to give a chance to thank the amazing team at ProTech
Yes.
for yet again putting on another great event. We love working with you, and especially Lindsay, you've been remarkable, as well as your colleagues who even thought of this event. And I also want to put a shout out to my team because I'm presenting ideas, but I work with a remarkable group of people who have worked day and night to make sure we know what we know and we can share what we know. We have a team of trainers. We have a team of experts. So when, let's say we have someone signs up for a PDF course, we're going to give you the person who knows PDF inside and out more than I do, which is pretty good too. So I just want to thank
Yeah,
all those people
and
before we go to
also
more.
shout out to Ellen from ProTech because it was really Ellen and David who came up with this idea. And Ellen is one of our reps and she's done a lot of work here. And in their work, they came up with this idea. And I'm only filling in for Ellen because she's been out sick this week. So normally Ellen would be here hosting this webinar. So thank you for letting me jump in front of the camera. I'm usually behind the scenes here at ProTech. But this has really come together. And I just want to say as a marketing person and someone who's on the side of updating websites, I have learned so much from David. I think one of my learnings is we will likely use Zoom for future webinars because there's a lot of accessibility things I've learned about even presenting webinars. So this has been a really educational experience and I hope everyone is taking some things away and we'll keep answering some questions here. So I think
Fantastic.
we were at what are the punishments if not meeting the federal requirements, federal
Yeah,
regulations?
that's right. And then Renee, I see in the chat as a follow-up question, which is if we do meet the requirements, do we need to update the DOJ or other system or agency? And Renee, that's a great question. I'm not aware of any requirement to have to notify the DOJ that you're in alignment with the with the law. So it's you don't have to report. So it's possible you could that if no one called you out on it, that the fines, which start at $75 and can go way, 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 way up, um, may never come to pass because no one complains or no one notices, whether they're in the community or they're in the federal government or the state government. However, I'm not aware of any reporting requirement other than receiving a demand of some sort.
The next question here is, what are the legal remedies for non-compliance?
Well, as I'd said, and Amy maybe already answered this earlier when I was responding to Renee's question, but indeed, the legal remedies are there are fines, and there's the potential of a lawsuit, and then see the history of this is because there were no measuring sticks in place over the last 10 years. There's it's been unfortunate that on any given day a judge would say, yeah, that does sound like a violation. That website isn't accessible enough, and deciding what the penalty should be. And on another given day, another judge may say, well, that's that's unfortunate, but let's just give them more time. So it's been it's been relatively inconsistent in terms of what the penalties or rulings have been up till now. But once the deadline is passed, the regulations provide a framework where the penalties should be far more precise than they've been in the past, as well as the measuring stick. Yeah, we got to be WCAG 2.1 compliant. No, we do not have to be WCAG 2.2 conformant. So this should tighten that up a lot, Amy.
Next question is from David Green. I'm not sure if David's still here or not. Is there a rough litmus test for which documents we need to make compliant? For example, age of the document, usefulness of the document, any of those kinds of criteria?
Yeah, that's an excellent question, David. So, yes to all that. So let me break that down. So David's first question is there a rough litmus test for which documents we need to make compliant? So the regs for ADA Title II are very specific. The documents you need to make compliant, with some exceptions for password protected documents and ones that are authored by parties that are not you, There are some, but the core groups of documents we need to look at are PDF files, Word files, Excel files, PowerPoint files, or their equivalent from other manufacturers. But 99% of spreadsheets, slide decks, word processing documents tend to be in the Office suite. So I'm just referring to those as examples. And those are the ones that are named. And then any other document format outside of those types of documents do not need to be made compliant. Except, I mentioned earlier, there are special rules for courseware, in which case all the document types need to be made compliant. Now, David's next question is, for example, age of the document. Well, if a document is old and is not going to change, then it can fall under the archive exception, where you're declaring that it's in an archive of documents which we have no intention of updating and are not actively needed in order to support a service. So this was the example I was giving before, where let's say we have the minutes from a board meeting or council meeting from 1956. We don't necessarily have to make that document accessible. However, and that document's been sitting on the site all along. So you can't post new documents that aren't accessible, but if that document's already been on your site for a long, long time, and you promise to never alter it or never update it, then you can declare it as archived. Except if it's a document we need that says to register your child for swimming lessons, you need to follow these instructions. And it happens to be a PDF file. And the swimming lessons are still happening, like there's ones in 2028, then that document, even if it's from 1956, needs to be made accessible. And so that I would fall under, so David, you say the age of the document, the usefulness of the document. I'd say it's not a continuum of usefulness. Is it currently required in order to participate in a program or a service, in which case it still has to be accessible. And then if you take a fine-tooth comb to the other exceptions, you'll find there's some other nuances there, but that covers 99% of the answer.
All right, well, I think that's all of the questions